Well, it's now 10:30, and that means it's time for Brainstorming the Human Connection. And this is a program brought to you by the South Dakota Humanities Council. I'm your host, Lawrence Diggs, uh, hailing from the sprawling metropolis of Roslyn, South Dakota. We are going to be having another interesting discussion today. You probably have been aware that there's lots of things happening relative to the Constitution. A lot of constitutional questions have been coming up. And in some ways, the Constitution is almost being redefined. It's like new things and ideas, novel theories have come up, and people are like looking at it in such a way that most of the people alive have not really heard about. I mean, like if you take like a Roe v. Wade, that was like, half the people in the country weren't born when that first got got started. So like redefining it, and also things like a presidential immunity, that was like has never been really a question that nobody rises above the law. But suddenly people are saying, oh well, maybe some people can rise above the law. you know so all of those kind of things like can find the population rather confused about, well, what is this thing that we're like we it's enshrined, this Constitution that we all feel like, okay, that is the bedrock of who we are. It guides all of the principles, all of the laws go under that. But what is it now? That's a question. So today we have with us Dr. David Adler, who has been with us before, but we're going to have him reintroduce himself for the folks that have not been privy to his extensive knowledge on the Constitution. And we're going to have a discussion with him about that. That said, I'd like to remind you that this is a conversation. Okay, so it's not just a couple of talking heads. We look forward to your questions, to your input, to your insights, to your perspectives. All of that's very welcome here. That's why we do it on Zoom instead of just do it on the radio, where it's a one-way passive experience. This, if you are to get the full experience of this, you can't get in more than you get out of it, more than you put in. So we'll encourage you to be paying attention, and then have some questions or comments, and be thinking. This is a thinking thing. That's why we're brainstorming, because we want to have different perspective. Welcome, Dr. David. How you doing?
Good morning, Lawrence. Thanks for having me. It's always great to be with you. I love this program and the opportunity to share some thoughts with your listeners and to exchange views with you. And you are so right. The Constitution is being redefined in front of our eyes. And for somebody who has studied the Constitution, written about it, lectured about it, as I have for 40 years, it's deeply disturbing. I'm, of course, president of the Alturas Institute, where we advance democracy by promoting the Constitution, civic education, equal protection, and women's rights. This is a moment in time where we should try to grasp the implications of all the sweeping changes that are occurring in this country. And as I have told my students over the years at various universities where I've taught, it's always important to check the reasoning of the Supreme Court, because sometimes the decisions rendered by the court won't pass scrutiny, that there are contradictions in the reasoning, there is no logical flow from premises to conclusions. And so not only do students improve their analytical skills by examining the arguments, but they begin to develop the kind of historical understanding that you alluded to about how the court can change its mind and essentially rewrite the Constitution, as it did in this executive immunity case that you mentioned. So I'm excited to be here with you at such an important juncture in American history. So thanks for having me.
Thank you for coming. Let's expand on that presidential immunity. What were the issues that were, let's say, up for grabs as far as what was presented to the Supreme Court, so we can look at what they finally decided?
In Trump versus the United States, and let's pause just for a second and think of the title of that case. This is former President, criminal defendant, criminal felon, Donald Trump suing the United States. Trump versus the United States was an issue that he raised in which he claimed that as a former president, he is entitled to immunity for his actions while undertaken in office. And this would make him essentially immune from criminal arrest. It would place him, for all intents and purposes, above the law. And of course, he lost in the federal district court, and the D.C. Circuit Court of Appeals on appeal did, in fact, uphold the lower court. So Donald Trump was 0 for 2 coming to the Supreme Court. And of course, the very idea that the Supreme Court agreed to hear the case was really surprising to the legal community for a couple of reasons, Lawrence. First, Jack Smith, the special counsel, had asked the Supreme Court way back in December, which is 8 months or so ago now, to take up the question of whether or not the President of the United States or former president enjoys immunity, as Trump had claimed, because he said, sooner or later, you're going to be asked to hear this case. Well, the Supreme Court refused to hear it, and it proceeded to hear oral argument in February. And then, as we know, it did not render a decision until the very last day of this 2024 term on July 2. And then the court rendered the decision that surprised us because it held fundamentally that the president enjoys absolute immunity from criminal prosecution when engaged in the conduct of his official duties, his official responsibilities, carrying out his official powers. But in areas involving unofficial acts, he is not immune. And so how to tell the difference? The court said, we've got to send this back to the federal district judge, Judge Chutkan, to determine where is that dividing line. And of course, what this did was to prolong the delay for holding former President Donald Trump accountable for his various actions, whether on January 6, 2021, when in the view of many, he incited the crowd to engage in an insurrection, attempting to stop the solemn constitutional process of verifying the electoral college count. Secondly, when he asked then Vice President Mike Pence not to accept the electoral college results from certain states, essentially telling him that as vice president, you have the authority to refuse to count those votes. And then, of course, sending out many tweets and communications urging people in other states to essentially swap out electors. And so for these and other actions, he had been essentially brought into court by Jack Smith, the special prosecutor, on charges that he had behaved unlawfully. That's how the case ultimately got to the Supreme Court.
And then that's how it got to the Supreme Court. Tell us about any complications that came up as a result of them filing this motion.
Yes, and that's an excellent question, very important, because when Donald Trump had been found by the federal district court as engaging in unlawful illegal actions to interfere with the 2020 presidential election, then that meant that the trial could go forward. And when Trump filed that appeal, when he filed the appeal to the DC Circuit and the DC Circuit upheld the lower court, then we thought that the Supreme Court would simply not accept the case because it was such an open and shut case. As you said, there had never been even any question about immunity for the president from criminal prosecution. If I could elaborate, it had always been assumed that a former president was, in fact, liable to charges that would bring about arrest and indictment for illegal actions. And that's why, to speak to the significance of the court's decision, when it accepted the case, it continued to delay the case and delay the moment when former President Trump would be held accountable, which is, of course, what he sought all the way. And the most significant impact of that, as you know, Lawrence, is that it meant that there would be no trial of Donald Trump before our November election. And so that meant that Americans would be going to the polls this coming November without definitive knowledge of whether or not the former president had 4 years before, in the aftermath of the 2020 election, tried to overthrow our government, incite a coup, foment an insurrection, and unlawfully and unconstitutionally interfere with the constitutional process, the final solemn step of counting the Electoral College votes. And so too many around the country, a majority around the country, the concern was, can we ever hold a president accountable? Is the presidency, in fact, subordinate to the rule of law, or is the presidency above the law? And to many, the court's ruling now was pretty clear. It places the president above the law. As Justice Sotomayor said in a brilliant dissenting opinion, it gives him the status of a king,
Wow.
a king in America.
One of the interesting things is, even in the court case, the issue was brought up as to whether or not he could actually have someone just assassinate his political rivals. And essentially the court said, well, that's okay, as long as it's official. At least, or am I reading something wrong there?
No, you're exactly right, Lawrence. In fact, the Trump legal team had argued that before the DC Circuit Court of Appeal, and Judge Pan, a very fine member of the 3-panel court that heard the case, wanted clarification and asked of Trump's attorney, are you saying, in fact, that the president could order SEAL Team 6 to assassinate his political opponents if he believes they represent a threat to our national security? The answer emphatically was yes. And so that was brought before the Supreme Court. And as you indicate, the court's ruling now envelops the authority of the president to order hits, to order assassination of political opponents if he believes that they're a threat to our democracy, our national security. And this essentially places the president above a law and clothes the presidency with a power that was simply unimaginable to those who wrote the Constitution.
Well, one of the interesting things that I noticed that didn't come up in that inquiry is, would it be okay for him to assassinate the Supreme Court? If
Right, that's right. That question didn't arise. But
cleverly.
That's right. And you know what? I appreciate your honing in on this essential point about the decision. So long as the president is carrying out his, quote, core constitutional duties, then his actions cannot be questioned because he is clothed with immunity. And so we're left to wonder, are there indeed any limitations? Could it be a former political opponent? Could it be a judge? There's simply no limits. And that's why I've written that this is the most pernicious decision ever handed down by the Supreme Court of the United States in our long judicial history. And that's saying a lot because there have been some pretty bad, dangerous decisions. But this stands by itself, Lawrence, because it represents a fundamental attack on the rule of law and on the Constitution, and bears no resemblance to the office that was created by the framers of the Constitution.
Well, it makes me wonder, what kind of structure do we have now? And I say that as a person who is very interested in law and order, because I feel like that's the thing that makes a society stable enough for us to cooperate together. If we don't have that, everything else is kind of thrown out the window. If we have no rules, it's like having 15, 20 different bands playing at a dance, like, well, what music do you dance to? The thing that comes to mind is, how do you make the case to a young person, let's say, growing up, that they should follow the law if the law allows some people to have advantages that other people don't? And if it's just a matter of power, and it's a matter of, let's say, who has the most guns or the quickest guns, or who can get away with it, or who's under the right flag, why should they obey the law?
Well, yeah.
That's the thing that I have to argue.
Well, that's a very important point. And Justice Louis Brandeis, in a famous Supreme Court decision in 1927 called Olmstead versus New York, said that the Supreme Court is the best teacher, the best role model in the country. And if it renders decisions holding that the government can behave unlawfully, that is going to send a message to the electorate, as you suggest, that they need not obey the law either. And so here we have a Supreme Court ruling that is essentially giving to the president a unique status that has no foundation in the Constitution. And probably what's most disturbing about this opinion is that it was written by a majority that advocates originalism, the idea that the Constitution should be interpreted in light of the framers' intentions. But this is in no way an originalist decision, which then means that this opinion seems very much to be an exercise in cherry picking and an exercise in judicial activism, the judges promoting their own ideology, their own preferences. And it means then that originalism is just a mask that
I've never.
what's on.
Oh, I'm sorry. Go ahead.
No, just a mask that the justices don as a means of justifying or rationalizing their decisions, and it becomes something of a masquerade.
Right. But for whatever reason, I've always seen that originalism and all of that. I've always seen that as a mask, because it always seems like it's a kind of a ratchet effect. If it works for whatever we wanted to decide, we say it's originalism and we can't go against the Constitution. If it didn't, it said, well, the framers were wrong. It's like we're
right.
back.
And well, and this case in particular, an originalist application, an originalist interpretation of the Constitution would focus on what the framers said in Philadelphia. And the framers, for example, as in the words of James Wilson, second in importance only to James Madison as an architect of the Constitution, said that the president would not enjoy any privileges not enjoyed by other American citizens. James Iredell of North Carolina said the president is amenable to the law. He is triable. And Charles Pinckney of South Carolina said the framers had considered briefly, very briefly, the idea of granting the president the sort of immunity that members of Congress enjoy when they're doing their business, coming and going, but they decided not to, because that whole generation, of course, lived in dread fear of a powerful executive, and the last thing they wanted to do was to create in America an embryonic monarchy that would remind Americans of the monarch against whom they waged a revolution to free themselves of a king who was above the law.
Right. I think Alphonse, we're going to turn now to give our esteemed panel here a chance to weigh in, ask questions, present various views. And Alphonse has had his hand up for a while, so I'm going to go with Alphonse. Are you there? Oh, did he? I think he was trying to open up his mic and he turned himself off. Okay, well, while he dials back on. Oh, was that him? Did he get back on? Oh, Lanico. Go ahead, Lanico.
Yes, good morning.
Good morning.
I just wanted to ask a question regarding um, the idea of originality is it shows or it encourages one to look at any kind of form as being malleable, have the potential for it to be shaped in a way that will correct whatever its intent was. So my question here was, well, another little analogy. You go to work for somebody and you're performing a job and you have certain expectations. Everyone who works with you has expectations based on what that job identifies to be your performance. However, built into that is an evaluation to examine what it is that you are doing and in what degree you are performing to the best of your ability. We have no structure that I'm aware of regarding the Supreme Court to examine the performance these individuals are doing, actually, to meet the needs of why they were elected or placed in that position in the first place. So that I would like to know why that has never evolved as a point of originality.
Yeah. I love that question, and it goes to a central feature of our constitutional system, and that is accountability of the government. James Madison had written in the Federalist Papers that what is critical in a government and like ours is the fact that the government would always be accountable to the rule of law and to the people. And you're right to say that there is no measure of accountability for the Supreme Court justices. Sure, impeachment is available, but it's only been exercised once, and that was way back in 1804 when Samuel Chase was impeached by the House, but he was rescued by the Senate. That is to say, he was exonerated, but by the slimmest of margins. One vote saved him from being removed from the Supreme Court. But in our time, with the deep political division that characterizes our nation, impeachment is essentially a toothless tiger. And so I think what you're talking about is the need to provide a measuring stick, an evaluation of the justices. And that's why so many across the country are talking about the need for Congress to pass a genuine ethics code that will bind the justices to make them accountable in terms of the gifts and the lavish trips that they take, or their participation in politics, which should not occur, and other similar acts. And so I think Congress needs to make that a priority in the next session, because to many people, the court is now a rogue court promoting its own views, turning back the clock in many ways to an earlier time period, and not being held accountable for it. And of course, just very recently, President Joe Biden has announced he's going to introduce a package of reforms, and I presume this is going to include an ethical code. Why is it, to your point, it's a very fine point, that in every other area of life, we work jobs or you run for other lower offices, there are means of accountability, but the Supreme Court justices seem to be above it all. And that gives them, I think, a sense of license, or at least a majority of them, and feel as though they have a license to redefine the Constitution, as Lawrence mentioned at the outset. So thanks very much for that good question.
I think Alphonse got his mojo back. And so can you push the right button this time? Are you there? Let's see.
Yes, it's my
there
connection.
You go.
My connection is not as. Can you hear me?
Can hear you, but you are breaking up though.
Okay. Well, my question is related to imbalances. Is the Congress no longer able to impeach and try a president?
You know, that's a very good question. Of course, the impeachment clause is as prominent today as it was at the founding. But the question is the willingness of Congress to utilize that mechanism, which Ben Franklin said was critical to the preservation of the Republic, because he said, without impeachment, there'll be no recourse but to assassination. What a remark to remember at this juncture, isn't it? But it's a way of holding an errant president accountable. But if it's not the case, as your good question raises, that impeachment is any longer a viable tool, or at least it seems to be placed in suspension, it's on the sidelines, then how do we hold presidents accountable? Because now with the Supreme Court's ruling in Trump versus the United States that a president is immune from criminal prosecution, where indeed are the elements of accountability for the American presidency, which was created by the framers with the understanding that it was subject to the rule of law. It's a very frightening time. And as Lawrence mentioned earlier, there are all kinds of unintended consequences of this Supreme Court decision, because ironically, it was former President Trump who was promoting this argument that the president could order SEAL Team 6 to take out his enemies, or perhaps in lesser terms, it might be the case the president could send somebody into exile. All those powers now, ironically, are in the hands of President Joe Biden. Would President Joe Biden, following Donald Trump's suggestions and the powers now vested in his office by this Supreme Court, exercise the broadest of broad powers in the name of preserving democracy, our national security, and send Trump abroad on a slow boat to a foreign country or something of a sort? Of course, I say that facetiously because Joe Biden is not a person who would do that. It's the other candidate who would aim to do that.
Well, what's interesting to me is that once you have that kind of feeling about the law, the filtering, the way that it trickles down is just horrifying, because it says, it's kind of like a Spartan thing. Whatever you can get away with, it's all good, man, because in the end, it's just about who, it's like, if you don't like something, if you don't like a decision, kill the guy, and if you don't like a particular point of view, assassinate all those people. Well, once you have that, then everybody else is forced to protect themselves by the same means, because the courts don't have any weight. And if there isn't respect for law, the result is chaos. I cannot see any intermediate state. Either you're going to have law and order, and the attempt, at least, for law and order, even if the police, let's say they are not doing their duty the way they could, even if you make that argument, but there's the expectation that law and order and people respect for the law, and the only reason you can have that expectation is if you expect that overall it's going to work for you. Yeah. If you don't think that the system of law is working for you, if you don't think it's better that we have laws and you're not subjected to whoever has the most guns and the most friends to come over and blow you up, then if you don't feel that, then your result, I mean, your recourse is to go out and try to get any guns or any other apparatus to kill people that you can. I don't see that as a viable solution for civilization.
Well, you're exactly right. Yeah, the reality here is that the court's decision is prescription for the kind of chaos that you describe. It is an invitation to lawlessness. It is an invitation to corruption in the highest office of the land. And a good example is when the court got round to discussing the pardon power, which of course is very much subject to abuse. We've seen it in our history, and it concerned the framers deeply, which, by the way, to go back to Alphonse's point, the framers believed that no president would abuse the pardon power because that president would be impeached. Well, if impeachment is not a feature of accountability, then the pardon power can be used for all kinds of corrupt purposes. A president now may take a bribe and pardon people. And ironically, it was the fear of bribery in the Constitutional Convention that animated the framers' discussion about the pardon power, because the King of England had taken bribes. And of course, the framers were familiar with that. So their concern in Philadelphia was how to cabin the presidential pardon power to prevent that. And that's when it was argued by Alexander Hamilton, among others, that the impeachment would lie for a president who would abuse the pardon power. So this is an invitation, as you say, to chaos, to lawlessness, to corruption. It's a dark constitutional ruling.
Well, the interesting thing is where do we go from here? Is there a path back, or can you imagine a path back to law and order, to the expectation that the legal system will treat everyone equally and fairly, justly? Is there a path back to that?
Well, I think that's a very good question. It all comes back to the question of who are the men and women who are judges in our country. You know, the Constitution is not a machine that would go of itself. It requires men and women of integrity to fill all the offices, including judgeships and Supreme Court justiceships. And so the only way forward, or the only way to correct the error of this decision, is for the court to be presented with another opportunity when it has a different composition, not dominated by three Trump appointees, for example, or three others who are very much advocates for strong executive power. And it can happen because, as we've seen, decisions can be overturned. Sometimes tragically, Roe versus Wade was overturned in the Dobbs decision. Voting rights have been shredded by overturning previous decisions. So there are opportunities for the Supreme Court to correct the mischief of decisions from a previous period of time. But who knows if that will occur, or how long that will take, and how much mischief can occur before that's overturned, if at all.
One of the things that occurs to me that in this conversation is it really speaks to how important every election is, that all of us participate in the election. Because we can say, oh, I don't like that candidate, I don't like this person, but it's not just that candidate and whether or not you like his tie or something. It's really about citizen participation in government. And if you actually don't want citizen participation, then you have no complaints. Whatever the rest of the government does, I don't want to hear from you, because you've basically said whatever it is, it's okay with me. If you don't want to, I mean, it's not that every election we make even the right decision, but not to be involved in it and to claim that, well, it's not important, those guys don't do this or that. Well, this is your basically fingernails, you know, grip on making it count. If those people don't do what you want, then unless we have one of these things that we're talking about now, where we basically give one person the power over everything. Well, go out and change it. You know, I mean, that is to me a testimony of why everyone should be involved in every election, not just the people, but the policies too. Lanico, you had something you wanted to say?
Yes, I'm just thinking about these term limits. We have situations in our government system where we got people in high places of authority that are lifelong terms. And as you can see, the human body changes throughout its aging process. And what used to be sound thinking at middle age may not be appropriately identified as such with elder age. And, you know, not to disparage aging, but when things change and the body is part of it, there needs to be recognizing a recognition, I should say, that terms that are in perpetuity are inappropriate for a governance of a large body of individuals, the nation. And so two things came to mind. First of all, the limitation of terms. And the second one is some tool or vehicle where the population being governed has an opportunity to be a part of a mechanism to change or evaluate or examine the performance of those in those positions.
Well, go ahead, David.
Well, I think that those are wonderful questions. Thank you, Lanico. The voice you use bespeaks the voice of the founders, who very much understood that life changes, that the Constitution needs to change over time so that it's adequate to the needs of our time or any future time. And some parts of the Constitution, as your question implies, become anachronistic over time. And that's measured by the fact that the American people have seen fit to amend the Constitution 27 times. And as you well know, we gave women the right to vote, 18-year-olds the right to vote. We have amended the Constitution to make our system much more democratic, much more reflective of the evolving needs of our country. And as you raise the issue of changes or reforms and term limits, I very much believe that we need to impose term limits on the Supreme Court. And I think President Biden's proposal is going to do exactly that, because, of course, now that we've seen the utilization or the exploitation of the process, and this goes back to your points earlier, Lawrence, which represent a very fine civics lesson, let me say, that every vote counts, and we're not just voting for the president, we're voting for U.S. senators. And when the Senate can abuse its power to manipulate the judicial process, as seen perhaps most notably in the refusal under the leadership of Mitch McConnell, the refusal of the Senate to even hold hearings when President Barack Obama nominated Merrick Garland to replace Antonin Scalia. And the Senate wouldn't even hold hearings on a flimsy rationale that they themselves tore up when it was convenient, that in an election year, we should wait for the people to decide whom they want to sit in the office, and that person should choose the next Supreme Court justice. And of course, they tore up that rationale after Justice Ginsburg passed away. And even though it was barely weeks before the election, they appointed Justice Barrett. And so the reality here is that we need to be mindful, as Lawrence says, when we go to the voting booth, that we're voting for presidents and also United States senators who make those crucial decisions. And the large point here, I think, the reason I like your question so much, Lenico, is the fact that we should all be mindful of the need to make relevant reforms to curb the excesses of power or to correct the misdeeds of those in power exploiting the system. And I think imposing term limits is a good reform measure, because now that we've seen a strategy of appointing very young federal judges who could serve for a very long time on the court, on lower federal courts and the Supreme Court, to promote political ideology warps the system, distorts it in the grossest way. So there ought to be a limitation of 15 or 18 years. I'm not at this point wedded to any particular number, but I think it's a remedy. And people say, well, you can't manipulate the Supreme Court or the judicial process. But let's remember that what the framers were doing, what they were engaged in, was creating a mechanism to bring different measures to bear to correct inadequacies in our system. So this is very much in keeping with the founding period, imposing term limits. And let's face it, we did this with the presidency, imposing a 2-term limit. So different generations at different times in our history have seen fit to reform the Constitution, to make it more adequate to the needs of our time. And by the way, the imposition of term limits, in my view, does not require a constitutional amendment. It requires a simple law passed by Congress, signed into law by the president, which simply say, when you look at Article 3, and it says that federal judges shall serve during, quote, good behavior, we need a statute that defines good behavior, and we say it is defined by an 18-year term in office. We don't need an amendment. Much easier to accomplish this, obviously, by a statute, much quicker.
Mm-hmm. We have one question that didn't get answered. Deb in the chat says, no one branch of government has supreme authority over the others. Will the checks and balances of the legislative and judicial branches not balance the authority of the executive branch even after this ruling? Does this ruling not continue to support the longstanding non-interference into the official actions of the president?
That's a very fine question. The reality here is that we're left to wonder just how far some presidents might take this newly minted power. It could be used to override any checking devices that are possessed by Congress and possessed by the Supreme Court, if a case were to come to the court, because ultimately a president under this ruling cannot be criminally indicted for the performance of his official duties. And all a president has to do, I'm so sad to say, is to denominate any action that he undertakes as the performance of his official duties. So this is a self-defining way to bootstrap the presidency above the law by just saying, what I'm doing here is an official duty, thus placing a tremendous burden on any prosecutor who would want to bring an action against the president, bearing a great burden to show, first of all, that the action undertaken was not official, and then secondly, showing that even if it's not official, that it doesn't enjoy limited immunity because it's so far removed from anything that a president might do. That vast orbit of official or pseudo-official actions undertaken by the president effectively builds a moat around the White House. And let me say this, and this is not entirely rhetorical, Lawrence. Once a president's term in office ends, how can a president be removed from power if he decides to stay? And of course, that's exactly what Donald Trump aimed to do after he was defeated fairly by Joe Biden in the 2020 presidential election. He did not mean to give up power. That's what the insurrection at the Capitol was all about, to stop the Electoral College count, to halt the peaceful transfer of power from one president to another for the very first time in our history. It was all about staying in power. And now with this Supreme Court ruling, if a president says that he's going to stay in power, and by the way, if I can take one step forward and you combine that with President Trump's Project 2025, which would give the president complete control over decisions by the Department of Justice, the military, Homeland Security, and the FBI, they'll all be acting under the direct orders of the president. And he can fill those offices with his own loyalists. So to go back to Lenico's question about checks and balances, and this question about checks and balances within Congress and the judiciary, the very other kinds of checks and balances available to us, such as the time-honored distinction between the White House and the DOJ, the vaunted independence of the Department of Justice would be shredded by the Project 2025. The willingness to refuse to carry out an unlawful order by the president, by the military, by the FBI, by the CIA, all depends on who is in charge in those departments. Returns us to the theme of the necessity of having men and women of integrity in those posts. But if they're filled with loyalists, which loyalist is going to refuse to do the bidding of a corrupt president who means to centralize all power in the office of the presidency? That's why Project 2025 is a prescription for authoritarianism. And this project has just been launched, aided, facilitated, choose your verb, by the Supreme Court's ruling that the president is immune from criminal prosecution. It's amazing.
Yes.
This is,
I'm going to go to Alphonse.
and sorry, I just had a quick
Oh, so,
follow-up question. Thank you, Mr. Adler. Who defines official and non-official, and how does a prosecutor argue anything if they don't have that determination?
That's an excellent question, and it's the key question to ask. So if a special prosecutor in a future case wants to bring an action against the president on the argument that the president has acted unlawfully, that prosecutor would bring the case in a federal district court. And the first thing that federal judge has to ask herself is this part of an official duty? And the president's attorneys are going to be in there saying, of course, it's part of the president's official duty. And it will be left to that judge, because the Supreme Court didn't provide any guidance along the way to distinguish official from unofficial acts. And so what we would have is a ruling by a judge. And then it leaves tremendous discretion to judges to distinguish official from unofficial. It can be fairly said that this Supreme Court followed the model in some ways of the court's decision in United States versus Nixon, the Watergate tapes case, which for the first time held that the president enjoys a limited executive privilege. It created a limited executive privilege out of whole cloth, because there was no executive privilege in the Constitution. The framers did not contemplate it. The court created it. And while at that time, when that decision was handed down, which, by the way, was handed down 40 years ago yesterday, in July 24, 1974, people applauded the decision at the outset because the court rejected unanimously Nixon's claim of an absolute executive privilege. But the court's great damage was holding that the president enjoys, quote, limited executive privilege, meaning that we would fight out exactly the extent of those privileges. And that is why the court in this executive immunity decision now has essentially translated privilege into immunity. So how ironic, the Supreme Court, referred to in Federalist 78 by Alexander Hamilton as, quote, the least dangerous branch, has just clothed the presidency with powers and features that place the president above the law by engaging in the process first by saying that the president had privilege, and now finishing the job, so to speak, completing the formula by translating privileges into immunities. And so what we would find anyway, in answer to this good question, is judges would have to draw those distinctions between unofficial and official actions, and the burden would always be on the prosecutor to demonstrate that they are unofficial actions. And the pernicious quality of this decision in the executive immunity case is that the court went so far as to say even some speeches are presumed by the president to be privileged, that is, immune, because they involve the president's communication with the American people. So if a president is giving a speech, as Trump did on the ellipse on January 6th, calling on the American people to, quote, fight like hell, or they're not going to, or they're going to lose their country, and you better march down to Capitol Hill, an incitement to violence, in my view, that's clothed with protection. And so a president enjoys now a sweeping immunity that defies the framers' intentions and essentially would have kept Richard Nixon in office, because when Nixon's team authorized the break-in of the Watergate Hotel to gather dirt on the Democrats, all Nixon had to claim was it was a national security operation that he had authorized, and he could not then be criminally prosecuted. Essentially, Nixon would not have been driven from office. So this court ruling, we might say, is Nixon resurrected. The theory that when the president does it, it is by definition legal. That's where we are now in this country.
Thank you. Thank you very much.
Alphonse, we're getting near the end, so I'm going to give you the last question, I guess.
Well, it relates to your point about voting and how we vote. I've been listening to an argument about really these positions, the presidency and then others who make laws, is about people of character. We are so far away from this concept of character in thinking about whom we elect. We have gone so politically towards just the politics, rather than whether or not someone's politics agrees with my personal or each other's personal politics, but rather the character of the nation is really at stake here. And I don't know how we do this. I'm no longer teaching as much as I used to, but we don't have the education that was called for to be able to run a democracy. I'll stop there.
You know, and I would, one of the things I was thinking as you were talking and others were talking, is it goes even before school, really. It's like, as a community, how are we training our young people as far as like being fair and how to develop their own moral code and moral compass? Are we instilling those moral codes and compasses so that people know right from wrong? Because even if we have the laws, it's like people who exercise those laws, and if they don't have any integrity or character, as Alphonse says, it doesn't really matter what we write down.
Yeah, that's so right. And I have to say, I really appreciate that question, Alphonse. Nice to talk to a fellow educator and to hear your concerns, which I share. The reality here is, in our short time, I would say, first, I wrote a column yesterday that runs in various South Dakota newspapers on the issue of presidential character and of presidents essentially willing to give up their office or to cede power in the name of a greater interest. That's what I think President Joe Biden did when he decided to step aside, because while he reveres the office, as he said in his Oval Office speech last night, democracy is much more important to him. And so there was an act, a big act, in the name of preserving democracy from his perspective, as George Washington had done earlier when he might have seized the reins of power at the end of the Revolutionary War. But as Cincinnatus, he dropped the sword and yielded to others, or he might have stayed in office for a second term. And we could go on and on. Your central point here is one that I take very seriously. I share your concern. We don't have enough emphasis on civic education throughout the country. And this is your central point, Lawrence, and it's a fine one. I agree with it. Couldn't agree more. And in fact, civics, so-called, as a broad term, should be taught every single year in elementary school all the way through graduation. And it should be a state requirement at state colleges and universities, because in a democracy, our people need to be educated. They need to understand how to participate in our political system. That's sharply distinguished from an authoritarian system in which citizens would not need to have those tools because they could never use those tools. That's the great irony here, is Americans could vote themselves out of democracy by supporting an authoritarian candidate, but they're never going to vote themselves out of authoritarianism into a democracy. That's the cruel irony. And so this is why, as President Biden said last night in his speech, the future's in our hands. And that's what these questions this morning reflect. We decide. We have to make the decision if we want to preserve democracy, how we're going to cast our ballots, for whom will we vote. It behooves us to learn as much as we can about our candidates, about the issues that are central to any particular election, and cast the wisest ballot that we can to ensure our future. But we must never, I think, be willing to vote ourselves out of democracy, because there's no way back to democracy short of revolution.
And I would add that not voting is voting. You know, it's if you can vote and you don't, you're actually voting whether you show up at the booth or not. So you know,
True.
Making an excuse, oh, I don't like the way his tie was, or that one time when he ran a red light, you know, and you go, that's not really a character question. That's not a big question. And to Alphonse's point, if you can find that people have character, a lot of the details kind of fall in the background. If it's genuinely a person who's trying to do the most good for the most people most often, a lot of the other things will fall under that.
That's so well said. So very well said, Lawrence.
And we're right down to the last few seconds of this program. I want to take this opportunity to thank all of you for showing up and exchanging views. We want to do this again next week at the same time in the same station. And I want to encourage you to, when you see a notice, to think about the subject and think about questions you might have, because we need everyone's participation to make this happen, much like government. A democracy is really an exercise in crowdsourcing solutions for our society. And the more people who participate in that crowdsourcing, the better the outcomes are likely to be. And if all of us are going to have to pay for it, you know, through taxes or going to war or defending our country against the war, or the results of those, then all of us had better participate. Thank you, everyone. We'll see you next time, same station. Join us.
Thank you.
Bye.